How do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you?
Senate confirmation hearings often oscillate between two extremes: lofty constitutional debates and meticulous legal technicalities. Senator John Kennedy of Louisiana has developed a reputation for steering hearings into both realms, usually with a mix of plain-spoken humor and sharp probing. In the transcript at hand, Kennedy engages judicial nominees on foundational doctrines like rational basis review, the difference between notice and fact pleading, and the interpretive philosophies that guide constitutional law. What emerges is more than a test of legal knowledge. Kennedy's questions force nominees to reconcile textbook doctrine with the practical realities of judging. He presses them on whether courts invent rationales for laws, how pleading standards affect access to justice, and perhaps most provocatively, how textualist or originalist approaches can be squared with universally celebrated precedents like Brown v. Board of Education. This commentary offers a thorough exploration of that exchange, unpacking the doctrinal stakes, the political performance, and the philosophical contradictions Kennedy puts on display. By the end, we see not only the pressure nominees face under questioning, but also the larger constitutional debates that animate modern judicial confirmation hearings.
Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic that's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe that Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
is,
the Constitution was passed?
I'm talking about right now. I believe that it's good
No, but
law,
I mean,
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Kennedy begins with what seems like a deceptively simple inquiry. What is the rational basis test? For constitutional lawyers, the rational basis test is a foundational concept. It is the most deferential standard of judicial review, applied when a law does not implicate fundamental rights or suspect classifications like race or religion. Under this test, a court asks whether the law in question is rationally related to a legitimate governmental interest. The nominee responds in textbook fashion, describing it as one of your least stringent tests. Kennedy immediately seizes on a potential gap. What if the legislature provides no reason for passing the law? Do courts then supply the rationale themselves? This exchange spotlights attention at the heart of rational basis review. In practice, courts almost never strike down laws under this test. Instead, they often hypothesize reasons a legislature could have had. Kennedy underscores this by asking bluntly, "So you just create the basis, the reason for the statute?" The nominee pushes back gently, claiming judges don't create reasons so much as interpret statutes in light of precedent and context. Yet Kennedy has surfaced a deep jurisprudential question. Is rational basis review a genuine check on legislative power, or merely a rubber stamp dressed in legal language? This matters beyond academic debate. Rational basis applies in countless everyday contexts: economic regulations, occupational licensing, social welfare benefits. When courts defer this strongly, legislatures have vast leeway to enact questionable or protectionist laws. Kennedy's questioning brings that deferential posture into sharp relief. Kennedy then pivots to a hypothetical. Suppose a legislature exempts college graduates from having to take driver's license tests. Would such a law survive constitutional scrutiny? The nominee correctly notes that because the classification is not based on a suspect category, like race or national origin, and does not burden a fundamental right, the rational basis test would apply. Kennedy presses further. Is there any conceivable justification for linking higher education with driving competence? The nominee admits that courts often invent rationales post hoc. Perhaps lawmakers believed education correlates with responsibility, or that graduates are less likely to engage in reckless driving. However thin, such rationales could be enough. Kennedy's point is clear. Rational basis review allows even absurd statutes to stand, so long as a court can conjure a conceivable justification. His hypothetical exposes the elasticity of the doctrine and its distance from democratic accountability. Legislators may pass a law without stating their reasons, yet courts will bend over backward to preserve it. This exchange reveals Kennedy's broader skepticism of judicial deference. While he often describes himself as a textualist, moments like this suggest he also harbors populist concerns about laws that serve entrenched interests under the veneer of rationality. From constitutional theory, Kennedy shifts to procedural law, asking nominees to distinguish between notice pleading and fact pleading. This is no small digression. The difference between these systems determines how easily litigants can bring cases to court. Notice pleading, the standard in federal courts under Rule 8 of the Federal Rules of Civil Procedure, requires only a short and plain statement of the claim. Plaintiffs need not detail every fact up front, allowing them to get into court and use discovery to develop their case. Fact pleading, by contrast, requires much more specificity from the outset. The nominee stumbles, confusing jurisdiction with pleading standards. Kennedy presses, pointing out that the federal system operates under notice pleading, not fact pleading. This correction demonstrates Kennedy's skill at revealing whether nominees truly grasped procedural fundamentals. But beyond the embarrassment of the moment, the issue is significant. Notice pleading has long been associated with broader access to justice, ensuring plaintiffs aren't shut out before gathering evidence. Yet recent Supreme Court decisions, such as Bell Atlantic v. Twombly and Ashcroft v. Iqbal, have nudged pleading standards closer to fact pleading, demanding plausibility rather than mere notice. Kennedy's question thus touches on one of the most contested aspects of modern civil litigation. By pressing nominees here, Kennedy highlights that judges must not only interpret constitutional theory, but also make technical procedural rulings that affect millions of ordinary litigants. Notice pleading, the standard in federal courts under Rule 8 of the Federal Rules of Civil Procedure, requires only a short and plain statement of the claim. Plaintiffs need not detail every fact up front, allowing them to get into court and use discovery to develop their case. Fact pleading, by contrast, requires much more specificity from the outset. The nominee stumbles, confusing jurisdiction with pleading standards. Kennedy presses, pointing out that the federal system operates under notice pleading, not fact pleading. This correction demonstrates Kennedy's skill at revealing whether nominees truly grasp procedural fundamentals. But beyond the embarrassment of the moment, the issue is significant. Notice pleading has long been associated with broader access to justice, ensuring plaintiffs aren't shut out before gathering evidence. Yet recent Supreme Court decisions, such as Bell Atlantic v. Twombly and Ashcroft v. Iqbal, have nudged pleading standards closer to fact pleading, demanding plausibility rather than mere notice. Kennedy's question thus touches on one of the most contested aspects of modern civil litigation. By pressing nominees here, Kennedy highlights that judges must not only interpret constitutional theory, but also make technical procedural rulings that affect millions of ordinary litigants. Senator Kennedy's questioning in this exchange may read at first like a law school exam: rational basis review, pleading standards, constitutional interpretation. But beneath the technical questions lies a broader performance about the role of judges in American democracy. Kennedy exposes the limits of deference, the stakes of procedural doctrine, and the contradictions of originalism. For nominees, these hearings are a tightrope walk. They must demonstrate competence without condescension, philosophical clarity without ideological rigidity, and fidelity to precedent without undermining their interpretive principles. Kennedy's style makes that walk even narrower. Yet for the public, exchanges like this offer a rare window into how abstract doctrines translate into real-world stakes. Whether in the deference of rational basis review, the accessibility of pleading standards, or the moral authority of Brown v. Board of Education, Kennedy's questions remind us that constitutional law is not only about theory. It is about the daily work of courts in shaping justice, equality, and democracy itself.